Assistant Public Defender.
Trevor Mabel for the people, Your Honor.
Assistant Public Defender Alexis Dipswith on behalf Mr. Daniel for case ending in 1320.
And Sherilyn Foster Tucker on behalf of James Daniel in the other case.
All right. What are we doing?
Your Honor, I may have preemptively submitted a green sheet, but after having further discussion with sister counsel, I believe we're going to set both matters for exam just to keep them together.
Discovery is complete on both matters.
To my knowledge, yes.
To my knowledge.
People, other witnesses available tonight.
Yes, sir.
Preliminary examination in person will be set September 9th, 2025, 9 a.m. That is before me in both matters. As a bond, I have a community corrections violation. Are counsel aware of that?
Yes, Your Honor.
Yes, Your Honor.
Would you like to address it? Because I issued a warrant. He's got a bond of $50,000 cash surety that's not been posted.
Your Honor, we would ask that his bond be reinstated. It's my understanding that his community corrections issue wasn't an attempt to evade drug testing. So he did initially go there, had that one drug test. The gentleman he spoke with said, "I'll see you next week." That's why he came exactly a week later to do his drug testing again. And that's when he realized he had gotten that different appointment from, I believe, a different individual he was speaking with at community correction. He did keep attempting to show up, albeit maybe not on the exact dates that he was supposed to. So it was never really an attempt to avoid the drug testing. Your Honor, he's more than willing to go test now. He indicated to both me and sister counsel that he would test clean if that was the case, except for possibly some THC.
He doesn't come in when he's supposed to test.
Your Honor, it's my understanding that
sometimes he just shows up or just doesn't report.
And I think the other issue, Your Honor, so he does work full time. He is working at a group home. Sometimes he's there at all hours of the day. So I think that has gotten in the way. He also does live in Wayne, Michigan. So sometimes it has become difficult for him to get transportation to here. But again, it was never an attempt to try to avoid drug testing. These are older cases, Your Honor.
He did.
He's willing to go test today and get everything set up today so we don't have any future issues, Your Honor.
It's not like they did anything the first time to him. He just kept doing whatever he wanted to do. Anything else?
I think Ms. Zerb's covered everything, but we would just ask that he be given another opportunity to enroll in testing and to show that he can be in compliance.
And Your Honor, if that was the case, we'd also ask that he be allowed to test closer to home because I think that was the main issue. Like I said, these are some older cases. He's been in treatment since these cases have occurred. So again, he would test clean if he were tested today.
Hasn't tested.
He tested the initial time, Your Honor, on August 1st, I believe.
I know. And then hasn't tested since.
Excuse me, Your Honor. Can I speak?
Go for it.
Yeah, I showed up. Yeah. When I tested, the guy told me he'll see me next week. When I showed up, the lady said I was supposed to be there the day before.
Correct.
And she said, okay, well, come back Monday. Monday I was at work, and I got slammed at work. I couldn't leave. I had to wait on my relief because I work at the group home. So I wasn't able to leave. I called. They said if I ain't there by 6 o'clock or something, then come tomorrow. I showed up the next day. The lady said there was a warrant out. When I signed in at the desk, it was like, it's true. She put a warrant out already. So I contacted my attorney.
Because you haven't tested.
But I showed up 2 tests. Every time, if she'd have let me test the Friday when I came, when she was saying I should have been there that Wednesday, but I was never told that I had to be there on a specific date. I just was told a week, next week.
Well, I'll reduce the amount that's on the warrant. The warrants are $50,000 cash surety. I'll reduce it to $25,000 cash surety, but defendant is remanded.
Good afternoon, Your Honor. Constable Bates on behalf of Mr. McFall, who was present to my right. Can you state your full name for the record, please?
Floyd McFall.
Your Honor, today is the date and time set for PCC. At this time, we're going to be requesting to set this for an exam.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available on the 9th.
Yes, Your Honor.
Preliminary examination in person, September 9th, 2025, 9 a.m. That's before
Judge Valvo.
Judge Valvo. We've got, you want to address the violations now?
Yes, Your Honor. I did speak with my client about the violation. He did attempt to turn himself in twice, and he was told that there was no warrant. Him and I spoke about it in depth. He understands how serious it is. Your Honor, if the court is willing, maybe to put him on a scram tether, and he will have no further violations in this matter. He's just asking for one more chance, Your Honor.
Response from the people?
Your Honor, we have concerns about McFall. I would note that it's not just one incident, it's 2 different days, and that the report indicates that when Mr. McFall was collected about the August 19th date, he admitted drinking, but then we have an August 24th date. So,
And also an August 26th date. It's on, that was, you may not have, well, you should have. There was one report on August 20th, which has those 2 on it, I think. Maybe not. No, the 19th, and then he drank on the 24th, but then further down, he also then blew and numbers on the 26th. But there aren't any other readings because he didn't take the follow-up test.
and so, Your Honor, part of the reason that we find it concerning, believe that alcohol may get involved with this, and that as far as the felonious assault charge, the alleged weapon is a wine bottle. So that's what gives us some concern. So I don't see why an alcohol tether is going to somehow ensure that Mr. McFall is with bond conditions that he seems to have violated them multiple times when he was confronted.
Well, Your Honor, in response, although a wine bottle is allegedly involved, that's because these allegations took place at a store. He was not drinking at the time. There was no, I don't believe there was an alcohol test taken at the time of arrest. So there's not really a substance abuse problem involved. And I would say that the tether would be a constant reminder that if he does end up drinking, he's going to be remanded.
So blowing into a machine doesn't do that?
Well, Your Honor, I think the tether on his leg is and I've had serious conversations with him, Your Honor. He's just asking for one more chance. He is here today. He understood that there was a warrant for his arrest. He still came in. He did try to turn himself in a couple days ago when I originally told him that there was no bond warrant. He does want to move forward, Your Honor. He's just asking for another chance.
3 occasions. Is he in any treatment or anything at this point?
No. Just at my church, I don't have proof for it though, and I did sign up for AA. I took like a hour-long test on it. I just got to get into.
Okay. Well, it looks like he is working on that, Your Honor. He's signed up.
Working on it.
Yes, he's signed up for treatment.
Between drinks. Bond revoked, defendants remanded.
And good afternoon, Your Honor. Laura Yaggi, Assistant Public Defender, with and on behalf of Mr. Strait. Your Honor, may we approach on this matter?
Approach.
Thank you, Your Honor.
Record should reflect you've had a bench conference in this case. I will grant your adjournment, but the bigger problem is regarding the defendant's bond. We release him from our jail, and in very short order, he decides to allegedly be in possession of a firearm and weapons. And at no point, because of previous conviction, he's a prohibited person and couldn't do that in any event. I understand he's maintaining his innocence in Livingston County, but those allegations are a violation of the bond in this case. Anything further?
Just for the record and for Mr. Strait's benefit, I did go over at the bench conference all of the 5 reasons we discussed as to request that your bond continue in this case, as well as, your adamant assertion of innocence in your pending case, you're in treatment, you're testing on you're supervised by 3 different methods, your treatment program, Livingston and Washtenaw. You sign up for another treatment program, you have a job interview tomorrow. And I verified with your Livingston attorney that you have no bond violations there. I did go over all of that with the court and the prosecuting attorney at the bench. So I have nothing further beyond that. And I, of course, showed the judge the documentation you brought to court.
Sure.
I'll adjourn this probable cause conference to September 4th, 2025 at 9 a.m. As I also indicated, the release to treatment order, I would sign that order when that's presented to the court. But at this point, given what I see in this case, defendant's bond is revoked, defendant's remanded to jail.